My name's Lee Fisher. I'm the Dean of Cleveland State University College of Law. And we're thrilled to have the opportunity today to talk about a subject that is front and center in America today, every single day, and perhaps never more so because we are in a hotly contested presidential election. So we thought it was appropriate today to talk about free speech. Recently, for the first time in the history of our law school, we administered a pledge to our first-year students. It was voluntary, but every student decided to take it. And I'm going to read just a relevant part of that pledge that each of the students took. I pledge to conduct myself with dignity and civility, and to treat all people with kindness, courtesy, and respect. And I pledge to support freedom of speech and diversity of thought, and to disagree respectfully, peacefully, and with an open mind. But I do want to emphasize those are values and norms. That's not the law. And today we're going to talk about values, norms, and the law. And we have three great panelists to talk about it. Kevin O'Neill, I would say this even if our entire faculty were here, and we do have a faculty member here today, Associate Dean Carolyn Boyne-Jacobs, even if the entire faculty were here, I would say what I'm about to say. He is the most beloved member of our faculty, the most popular with the students, and happens to be a national expert on First Amendment. Now live up to that, Kevin O'Neill. Okay, we also have here today one of only two people, I believe, who've ever received the distinction of Distinguished Professor. Maybe one of three people. Richard Perloff is the third designated CSU Distinguished Professor by President Bloomberg, and it's quite the distinction. But Richard Perloff has a national reputation, and we are honored to have him today, and he's going to be giving not so much the legal background, but the political and sociological background of the First Amendment and free speech. And then finally, we have our lawyer, all of our lawyers, the general counsel for Cleveland State University, who's going to talk particularly about the policies and practices of our university. I'll ask maybe one question, and then we're going to open up to the audience. And if there's silence, I'll ask a second question. So with that, I introduce to you the most beloved professor and the First Amendment expert, Kevin O'Neill.
Thank you. I'm also, people don't know this, but I'm also the faculty member most easily confused. So that's, I don't get quite as much recognition for that. But all right, now I promised that I would not go more than 12 minutes. So I'm going to start my 12-minute timer right now. And I will stop mid-sentence when I hear this thing go off. All right, so what am I doing here today? I'm going to give you a primer on basic First Amendment law regarding the speech clause of the First Amendment. I want to make a couple of major points. First, point number one, the First Amendment restrains the power of government to regulate speech. It does not restrain private actors. That means that a public university like CSU is restrained by the First Amendment, but a private university like Case Western Reserve is not. Now, point number two, this is the most important point that I can make today. Under current law, the government has substantial leeway to regulate the time, place, and manner of speech, but it is sharply restricted in its power to restrict the content of speech. Now, why is the Supreme Court so hostile to content-based restrictions on speech? In a word, it's because of our history, a history in which the government repeatedly punished the expression of controversial views. Let's go back to the pre-Civil War South and look at some of these ferocious punishments if you criticize slavery. There was an 1849 Virginia law that imposed a 1-year jail term and a $500 fine for saying or writing that owners have no right in the property of slaves. In North Carolina, the punishment for this speech crime was a lashing and 1 year for the first offense, death for the second offense. In Louisiana, the penalty for conversation having a tendency to promote discontent among free colored people or insubordination among slaves ranged from 21 years at hard labor to death. Now, these are speech crimes. Let's take a look at the suffragists who were trying to obtain, not a terribly controversial viewpoint, it was back then, not too controversial now, I hope, and that is they were trying to get the vote for women. Here they are protesting in front of the White House in 1917. By the way, the suffragists were the first protesters ever to use that iconic space, but they were arrested. Hundreds of them were arrested. Here's a suffragist demonstrator being arrested in front of the White House. And look at Occoquan Prison filling up to overflow with women arrested for simply seeking the vote. How about radical labor speech? The industrial workers of the world urged the rejection of capitalism and also the formation of one giant industrial labor union. Here's one of their protesters in Spokane, Washington in 1914. Here's, you can see that they had large rallies, this one in New York City. And local governments cracked down hard on them and arrested them en masse. And here's what the federal government did. This is the IWW office in New York City after being ransacked in 1920 during the Palmer raids. And here is, on the left, the leader of the IWW, William Big Bill Haywood, who was arrested and given a 20-year jail sentence for having the wrong views about capitalism. And notice that in these raids, notice what's being seized. Their literature. That's the evidence against them, their ideas. And then we come to the socialists who opposed our entry into World War I. And the great socialist leader, Eugene Debs, he's giving a speech in which some draft-age men were present. And so he's accused of interfering with the military draft. He is criminally prosecuted by the federal government, receives a 10-year jail sentence, and the U.S. Supreme Court upholds that sentence. So, at this point, and so there he is, he's incorrigible, he's running for president from jail in 1920. So at this point, look who enters the spotlight, the two of the greatest Supreme Court justices of all time. Well, first of all, let's just get the stats out. In all, the federal government prosecuted more than 2,000 individuals for expressing opposition to U.S. intervention in World War I. So at this point, two great Supreme Court justices, Oliver Wendell Holmes and Louis Brandeis, step into the spotlight. And in dissenting opinions written in the 1920s, they offered a total reformulation of our approach to free speech. They said that the government has no business restricting the expression of viewpoints, of ideas. Look what Holmes is saying in this Abrams dissent, urging protection even for opinions that we loathe and believe to be fraught with death. Brandeis linked free speech to the fact that we have a democracy where the people are supposedly the sovereign. So in a functioning democracy, Brandeis argued, the government has no business serving as a content-conscious gatekeeper, allowing some ideas into the marketplace of public discourse, but keeping others out. And those are dissenting opinions in the 1920s, but they captured the Supreme Court later in the 20th century, and those views now represent the core, the bedrock of First Amendment law. So, to sum up, under current First Amendment law, Content-based restrictions on speech are almost always struck down, and viewpoint-based restrictions are never allowed. So what's the difference between a content-based and a viewpoint-based restriction on speech? Let me give you an example. Let's come up with a local ordinance. I'll give you two different versions, one content-based and one viewpoint-based. So what does the content-based restriction say? No person shall comment on Mayor Bibb's performance in office. Notice what that is. Let's take a topic and just remove it from the realm of public discourse, okay? Now, even worse from a First Amendment standpoint is a viewpoint-based restriction. What would that look like? No person shall criticize Mayor Bibb's performance in office. So you're free to praise him, but you dare not criticize him. The U.S. Supreme Court regards viewpoint discrimination as an egregious form of content-based discrimination, and so it is presumptively unconstitutional. All right, so what about, I mentioned at the beginning, time, place, and manner restrictions. So what do time, place, and manner regulations look like? Well, on the campus of a public university, time, place, and manner regulations might entail limiting the on-campus locations where protests may be staged, imposing durational time limits on how long a protest may continue, restricting or banning on-campus encampments, restricting or banning the use of sound amplification equipment, limiting the number of protesters who may occupy a given space, banning early morning and or late evening demonstrations, and restricting the size or placement of signs on campus. Now, to recap, viewpoint-based restrictions are presumptively unconstitutional. Content-based restrictions are gauged under a strict scrutiny test, which I don't have time to get into. But under this strict scrutiny test, they're going to be struck down 99% of the time. Let me go back. Time, place, and manner regulations are gauged under a more deferential standard. The intermediate scrutiny test, I don't have time to go into that, but that's a more deferential standard where a regulation does have a decent chance of being upheld. So why does the government have greater leeway to impose time, place, and manner regulations? Here's why. If they don't threaten viewpoint or ideas, then they are not the same kind of grave threat to our First Amendment values. So if you have a content-neutral time, place, and manner regulation, it doesn't threaten the core concerns of the First Amendment with regard to protecting content and viewpoints. So it's subject to a more deferential standard and has at least some chance of being upheld. Now, certain categories of speech are completely unprotected by the First Amendment and are therefore vulnerable to content-based regulation. So on this chart, everything on the left-hand side, those 5 categories, those are completely unprotected speech categories. Notice that hate speech is nowhere to be found on this chart. Hate speech is protected. If you want to regulate hate speech, you have to find one of those 5 completely unprotected speech categories and regulate hate speech within the safe harbor of those completely unprotected speech categories. All right. Now, let's see, I got a minute left. Let me just introduce the public forum doctrine, which is the bedrock of public protest law. Here's a massive demonstration in Los Angeles after George W. Bush invaded Iraq. Access to public property for speech-related activity is governed by the public forum doctrine. Government-owned property has been divided into 4 categories for purposes of forum analysis. Traditional, designated, limited, non-public forums. If we have time later, I can go back and describe those. They are described in this chart. In forum analysis, the government's power to impose speech restrictions depends on how the affected property is categorized. The level of judicial scrutiny hinges on whether the property is deemed a traditional, designated, limited, or non-public forum. Now, traditional public forums may be regulated. There we go. Did I stop in the middle of a syllable?
You
I'm not
can
sure
keep
that's
going.
physically possible, but that's but in any event,
Feel free to finish up, Kevin.
Oh, well, okay. Actually, very quickly, here's the point I wanted to make. The campus of a public, now the U.S. Supreme Court has never held this, but the lower court decisions are unanimous in holding that the campus of a public university is generally regarded as a non-public forum. But even in a non-public forum, if we go back, that three-prong intermediate scrutiny test does not apply. It's a reasonableness test that is used to gauge restrictions on speech in a non-public forum. But the courts police for viewpoint-based discrimination. So even in a non-public forum, the government may not engage in viewpoint-based discrimination. I think I should stop now. I've been hogging too much time, but thank you for your patience. I hope that was helpful.
Before I ask Richard Perloff to get up, I'm going to tell you a quick minute-and-a-half story. When I was a state senator, I wrote Ohio's hate crime law, and then years later, the ACLU challenged that law as unconstitutional, and I defended the law in the Ohio Supreme Court. And the person who challenged that law as unconstitutional was Kevin O'Neill. He was the general counsel of the Ohio ACLU, and we argued together. I argued that the hate crime law was constitutional. He argued that hate speech is protected, and he won the case. The Ohio Supreme Court ruled the hate crime law unconstitutional. But it was appealed to the U.S. Supreme Court, reversed the Ohio Supreme Court, and the hate crime law today is constitutional. That's the story, the short version of that story. Okay, now, Richard Perloff. Richard.
Well, Professor O'Neill offered a comprehensive legal foundations of campus speech. And what I want to do is different. I want to take a look at free speech from a more psychological perspective, the ways that conformity pressures on campus can induce students to self-censor themselves, and what we can do to encourage robustly, what we can do to encourage, yes, I can tell myself, what we can do to encourage robustly free speech. And so, I begin with a question, one that strikes to the heart of free speech-related controversy, which we know. Is the slogan, controversial, from the river to the sea, Palestine will be free, anti-Semitic? Okay, a lot of views on that. I want to come back to it. But I want to come back to unpacking the different meanings, but first a little social psychology that will help us see it from different vantage points. For your answer on how you view the slogan will depend on your racial, ethnic, religious attitudes, social psychological views, and how you answer the question about other issues. The fraud issue of whether microaggression occurs depends in large part on your pre-existing attitude, your experiences, your social identity. That's the conclusion of years of social psychological research, offering empirical support for the famous adage offered up by Nelson Mandela, that where you stand on an issue depends on where you sit. Now, over the past 2 decades, microaggression, other aggressive comments have become very, very topical. The first thing to remember about all of this, I want to suggest, is to a large extent bias is in the eye of the beholder. Not always, but sometimes and frequently. So when one person charges another with microaggression or a prejudiced remark, they may be 1,000% right. Or they may well be, and that's happened sometimes. Or they may be projecting their own emotional needs on the other person. I've come to the phenomenon more generally in my own research over the past 30 years in the areas of perceptions of media bias, the social psychology of where we assume not that the media is objectively biased, but we see it as biased. It's the subjective perception the media are biased against my side, my group, and it's held when people have a very strong attitude on an issue. It's not the familiar issue the media are objectively biased, but observers' strong perception the media are biased and against their side. Psychologically, people perceive that for a number of reasons. Thus, pro-Israeli partisans perceive the news media coverage ongoing of the Israeli-Hamas war, now Hezbollah, was blatantly biased against their side because they thought it showed Israel in only a violently aggressive light. But pro-Palestinian partisans felt the coverage was blatantly biased against their side because it frequently quoted Biden and Secretary of State Blinken defending what Israel had done. It's the same with other issues as well. We perceive the media is biased against our side, even if their content is more nuanced. If think of a cause you feel strongly about, I bet you've perceived the media are hostile to your side. Now let's apply the construct that underlies perception of hostile media bias, strong personal attitudes, to the issue of free speech on campus protests. For staunch pro-Israeli partisans, the slogan held up at many protests last spring, "From the river to the sea, Palestine will be free," was blatantly anti-Israel, and even anti-Semitic, because what is between the Jordan River and the Mediterranean Sea? Israel. Thus, they saw it as a blatant call to eradicate Israel, pure and simple, no matter how it's disguised. But Palestinian supporters didn't see it that way. They saw it as a cry to core for a free Palestine, as an aspirational call for human rights. It didn't necessarily mean the term free literally, but in terms of eliminating Israel, but free psychologically. That when people are most free when they have a homeland with which to identify. So what happens at campus protests on this and other issues is that the interpretation that one side has for an issue is demonized and viewed as hostile to their side, rather than it should be as one interpretation of a multifaceted, multi-perspectival, complex historical situation. Now to be sure, there are comments and interpretations that can be 100% biased, racist, prejudiced, anti-Semitic, not deserving of hearing, and under some conditions, hate speech. But in many cases, such as the river to the sea slogan, the divergent perspectives are denied or ignored, and partisans demand that the protest be halted, that the speech of their, taking my time here, that the speech of their side violates, it constitutes hate speech and should be banned, taking their cue from the 60s philosopher Herbert Marcuse, who was not a libertarian. And this is a really good quote. As Supreme Court Justice John Marshall Harlan said, "One person's vulgarity is another's lyric. One person's vulgarity is another's lyric." When people have strong and passionate attitudes, which can be good, they go to the extremes and sue or threaten those whose speech they oppose. A classic example of the hostile communication bias. But for large numbers of students who don't have strong political attitudes, there's another perspective. For many students, the whole campus environment can feel unpleasant, intimidating, and they're afraid they'll be accused of saying a microaggression on one side. As a result, they choose not to speak. One survey found that more than 40% of students felt uncomfortable expressing their opinion on a controversial topic during an in-class discussion. But in other cases, students who are members of cultural minorities can feel silenced because a mean-spirited comment by someone with a more cultural status is so insensitive, so devastating, and touches them so personally they don't want to engage at all. The issue is not just intellectual for them, it touches on their culture, their social group, and who they are. They are hurt to the core. So students self-censor themselves for a variety of reasons. They self-censor for the exact opposite of free speech the university wants to encourage. Or as two communication researchers put it in a clever double entendre, politics and speech is what goes without saying. Politics and speech is what goes without saying. And when students choose not to speak out of fear of social consequences, real or imagined, they produce a distortion in the climate of opinion, which is now deprived of the many moderate or otherwise nuanced voices. And therefore, the climate on campus seems more extreme than it really is. The perception then serves to justify students' reluctance to freely speak their minds. What public opinion scholars call a spiral of silence has occurred. And Government, from a First Amendment perspective, the concerns with government silencing speech. But government is not the only silencing force. From a social psychological perspective, the concern is that wittingly or unwittingly, campus norms, sometimes progressive liberals, other cases religious conservatives are dominant, perceptions of those norms, and the emotional fears of offending peers with perceived power can silence student voices. Yet on a larger level, on a societal free speech level, this is problematic. As John Stuart Mill, the great political philosopher and amazing feminist, noted in reference to the dangers of censorship and self-censorship, if the opinion is right, people are deprived of the opportunity of exchanging error for truth. If wrong, they lose what is almost as great a benefit, the clearer perception and livelier impression of truth produced by its collision with error. So universities need to teach the importance of civics and civil speech. They need to help students to find ways to listen and express their attitudes outside social media, for social media encourages like-minded speech that only reinforces biases. We need to develop forums to bring people with different attitudes on topics together. Students want colleges to foster open dialogue, yet surveys show that only a third of students believe their colleges or universities provide programs that encourage debate. Students need to be exposed to people with different attitudes than their own, but it has to be done in spaces that foster give and take, that offer respect for those who may be reluctant to talk because they lie outside the cultural majority, and allow students to feel that the discussion will try to transcend partisan differences. James Fishkin, a Stanford political scientist, has had a lot of success over the years with the bridging of political differences over the years with his deliberative poll where he's brought liberals and conservatives together in a neutral campus, and he's found they have more understanding. In this vein, a nonprofit group, One Small Step, brings two people from different backgrounds together in a room with instruction, don't talk about politics, don't talk about politics. In one case, they arranged for Alton Russell, an 85-year-old white toilet paper salesman who chaired the local Republican Party in Georgia, to meet Wayne Hales, a 60-year-old black newspaper owner who served as president of Georgia City's NAACP chapter. As they talked, they found they liked each other. How can you be mad at somebody who sells toilet paper? Hales asked. Wayne's just a regular old person, Russell chimed in. They bonded in ways that could have led to more understanding of their partisan differences. So, in encouraging free speech on campus, this could be a model that could encourage civics instruction and training at Cleveland State of the variety of projects that our law school dean, Lee Fisher, is involved with. So in encouraging free speech on campus, we need, as best we can, to separate out the personal from the political argument. To remember that all of us are not as fragile as we think we are. We must recognize that a social or political criticism need not be a personal attack, even if we feel that it is. We should be safe from harm, but not safe from ideas. When someone says something we disagree with, our first response should not be, that's personal, how dare you say that, and you're wrong, but that's their argument. Is that, oh, wait a minute, is that, oh, well, what's that argument? What are the chances? But is that cogent or unfair, and what's a good way to offer a rejoinder? Students, faculty, all of us really, should remember our human fallibilities. We can be wrong. And intellectual humility is a virtue, not a vice. As Benjamin Franklin famously suggested, you know this quote, we should view our critics as our friends for pointing out the correctable errors of our ways. So summing up, as a university, we want to encourage students to find it within themselves to politely, polemically, but persuasively learn that the response to an idea they find offensive or misguided is not suppression of speech, but robust counter-speech that challenges an insult with an idea and illuminates an attack with an argument, in this way expanding and enriching the understanding of social problems and the universe of potential solutions. Once again, John Stuart Mill. The only way in which a human being can make some approach to knowing the whole of the subject is by hearing what can be said about it by persons of every variety of opinion and studying all modes in which it can be looked at by every character of mind. In other words, free, vibrant, intellectually diverse, analytically intelligent, philosophically tolerant, and spirited, robust speech. That is our mission. Thank you.
Professor Perloff, thank you. I should have mentioned in my introduction to Professor Perloff that he's with the Levin College of Public Affairs and Education, and our dean of that college is here today, Jill Gordon, who's got her hands up like that. Right. And I always should mention the college, and I apologize I didn't do that, Jill. Last but not least is our general counsel, Sonali Wilson. And Sonali's chosen to sit rather than stand, which is permitted. Time, manner, and place is up to you. Okay, go ahead.
Thank you, Dean Fisher, and thank you, Professors O'Neill and Perloff, for setting the stage for how do we exercise free speech on Cleveland State University's campus. Okay, the first thing to remember about free speech on a university campus is to look at what type of university it is, and I believe that Professor O'Neill did say there's a distinction between a public and a private institution. Cleveland State University is considered the government because we're a public university. We're an instrumentality of the state. And so that's what governs how free speech can be exercised on our campus. There are a myriad of laws and now policies and procedures that help form parameters around free speech on campus. The first would be the United States Constitution, which Professor O'Neill talked about, the First Amendment. Government shall make no law abridging the freedom of speech. Government means what? Cleveland State University in this context. The Ohio Constitution, Articles 3 and 11. In 2019, the Cleveland State University faculty and the administration presented and passed a joint resolution, the Joint Faculty Senate Administration Resolution, which was in 2019, and I'll talk about that in a little more detail. Then in 2021 and 22, the Ohio legislature passed laws that directly affected free speech and required all public universities in Ohio to have a free speech policy, which that was never a requirement before. And then from that, we have the university policies and procedures. The policies are what? What is free speech? Who has the right? And the expressive activity policy and its procedures, how do we exercise those rights on CSU's campus? So the Joint Faculty Senate Administration Resolution, again, was passed March 6, 2019, and I must say that the faculty brought this to the administration. This was at a time in 2019 where there was a lot of political activity across the country, and a lot of schools were canceling guest speakers and student speakers and so forth because of the content of their speech may have been controversial. And the faculty brought this and said, we honor free speech reigns on Cleveland State's campus, and we agree with this resolution. It is on the free speech website for Cleveland State, but I just want to read one paragraph because I think it kind of captures the essence. Because Cleveland State University is committed to free and open inquiry in all matters, it guarantees all members of the university community the broadest possible latitude to speak, write, listen, challenge, and learn, except insofar as limitations on that freedom are necessary to the functioning of the university. Cleveland State University fully respects and supports the freedom of all members of the university community to discuss any problem that presents itself. And I think that captures the whole tenor of what that resolution was. And at that time, it earned the university, we were the only public university in the state of Ohio to receive the green light from FIRE, which is the Foundation for Individual Rights and Expressions. And that was quite an honor for us to be the only one that achieved that. As I said, in 2021-22, the Ohio legislature passed the Forming Open and Robust University Minds Act, which is the Forum Act. And the law was passed to reaffirm that lawful free speech not be obstructed on the campuses of Ohio State's institutions of higher education. And those are found, the law itself, the Forum Act, is found in those sections of the code that are noted up above. A few provisions from the Forum Act include Outdoor campus areas are public forums for campus communities. This does not include outdoor areas where access is generally restricted, such as athletic fields. This would receive the highest level of constitutional protection, and Professor O'Neill was going into public forums and non-public, and it can be really a complicated thing, but note to say that the outdoor campus areas, and under our policies and procedures, those are public forums. The Forum Act also prohibits free speech zones. Now, at one time before this, some universities designated an area, you can only have free speech over in this open area, but that's no longer permitted. So you can't have free speech zones or areas where expressive activity is not permitted. Also, no state institution of higher education shall charge security fees to a student or a student group based on the content of their expression, the content of the expression of their invited guests, or the anticipated reaction to an invited guest expression. We did have some schools, and I think Kent State was in the middle of one of these, where they were charging a student group more because it was anticipated that the person that was coming to speak would cause violence and upheaval on the campus. And there was a decision that you can't do that. Well, the legislature enacted this Forum Act and included that in there because not all the courts were following suit and having the same case law around that, and so, but now it's codified in the Forum Act. Also, state institutions of higher education may maintain and enforce, and we heard Professor O'Neill speak to this, reasonable time, place, and manner restrictions in service of significant institutional interests, such as safety, and to maintain order on campus. Only when such restrictions, though, they must be published, and they must be viewpoint and content neutral criteria, and must provide for ample alternative means for expressive activities. From the Forum Act, the university did pass the campus free speech policy. It affirms students' fundamental constitutional right to free speech. The university is a marketplace of ideas. It indicates that CSU should not shield people from offensive, unwise, immoral, or indecent ideas, as Professor Perloff was speaking to. And students and faculty cannot substantially obstruct or interfere with others' free speech rights. That's very important, the tolerance piece that we were hearing about. The campus free speech policy at CSU can enforce constitutional time, place, and manner restrictions, enforce reasonable viewpoint neutral restrictions in non-public forums, establish and enforce classroom rules, restrict the use of CSU property for the university's mission, which would be educational, instruction, and related activity. Unprotected speech. I think that Professor O'Neill went through that: obscenity, defamation, incitement to illegal activity, true threats, fighting words, and harassment. And I just want to say one thing about harassment, because that's something that my legal team is here, that we often, will hear about, well, I feel harassed or I've been harassed. And that's a specifically defined concept in the Forum Act. And it states, in the act itself, it's defined, harassment means unwelcome conduct that is so severe, pervasive, and objectively offensive that it effectively denies an individual equal access to the individual's education, program, or activity. So severe, pervasive, and objectively offensive. So all of those elements have to be present. And Professor O'Neill, you're looking at this, and this is from the Act, so I know case law may have differed on that, but the Act itself defines it that way. I think it may even be different in some states. Now, the expressive activity policy, which we had prior to the campus free speech and the Forum Act. But really the expressive activity policy and its related procedures, that's really the how. Free speech is the what, who has the right, of free speech. Our expressive activity is how to exercise free speech rights on the campus. So expressive activity means, under our policy, and that's our policy number, means any non-commercial, lawful, verbal, written, audiovisual, or electronic means by which individuals may communicate ideas, including all forms of peaceable assembly, protest, speeches, distribution of literature, carrying and displaying of signs, and circulating petitions. That comes straight out of the expressive activity policy. Our expressive activity procedures are also found, all of these things, the free speech policy, the expressive activity policy, the procedures, they're all found on our newly minted free speech page, which we'll talk about last. So the procedures go into a little bit more detail on the reasonable time, place, and manner restrictions, again, that must be content neutral. And some of those include any person or group may use outdoor areas of campus for expressive activity. They may use them. However, they cannot block walkways or interfere with any university operations. So when you get to the procedures, it gets into the nitty-gritty, like noise levels, and you know, so if some students have give a presentation in the quadrant outside, now I can't think of that open space in between the library and the student center, during certain times, noise above a certain level is prohibited because there's classrooms in the adjacent building in Berkman Hall. So those would be reasonable time, place, and manner restrictions in terms of when can activity take place, how loud can it be, and that kind of thing. Also, you can't have free speech zones. If you're likely to draw more than 100 persons, you're asked to contact the CSU police so that they can prepare for large groups. That's a content neutral. It's more geared toward crowd management and security, that type of thing. And of course, again, we can't charge students for that. That's a decision that the university would make. Indoor areas can be reserved through conference services for free speech activity. The procedures again drill down into the specifics of what you can and cannot do with respect to free speech on campus. The prohibitions: can't distribute university operations or damage property, no harassment, and I read the definition of harassment to you earlier, no distribution of materials on car windshields or littering, and the heckler's veto, which is something that is interesting, that's specifically called out in the statute, which had been previously in case law and kind of hard to define, but here they say you cannot disrupt another's expressive activity. That's essentially what the heckler's veto is. Now, the Forum Act requires that every school have a method to report the violations of free speech, and so this can be done in 3 ways. You can report a concern through our Concerned Bikes page. Also submit a complaint through Ethics Point, which is anonymous or can be anonymous, and then we also have free speech complaint procedures. And so those would be the 3 ways that if one feels that their free speech rights have been abridged or violated on campus, then the Forum Act provides that we must allow and have a complaint process for that. Then last, as I mentioned before, we do have the CSU Free Speech website. All of the policies and procedures are there. The faculty resolution is there, the faculty administration resolution, the different links to file a complaint, to file a report, and so forth. So hopefully you'll find it very useful, and everything can be found there. Thank you.
Excellent. Thank you, Sonali, very much. Before I open it up to all of you, I'm just going to ask one question. I did not tell our panelists I was going to do this in advance, primarily because I just thought of it. And that is, I'm going to propose 2 hypotheticals and ask you to react to them. The first hypothetical is that a conservative student organization on campus It could be any campus right now, and you can comment on whether the difference would be public or private. A conservative student organization invites a conservative federal judge to speak. This conservative federal judge has taken anti-LGBTQ plus positions, both in his legal opinions and in his personal life. The students asked the student organization to withdraw the invitation. They refused. The speaker comes. There are students in the hallways with signs saying that this speaker shouldn't have been allowed. And as the speaker walks into the auditorium, there are about, let's say, a dozen students actively booing the speaker and preventing him from speaking. That's hypothetical number one. Hypothetical number two, a student is speaking at commencement, college commencement, and the student indicates to someone on the faculty in advance that they're going to be talking about an issue that could be perceived as either racist, anti-Semitic, or anti-Palestinian racism. Does the university have the right to tell that student either not to speak or to take that out of the speech in advance? Those are my two hypotheticals. You can comment on both hypotheticals, one of them, or I suppose neither. But I hope you don't choose that option. Kevin, I'll start with you.
Okay, well, so the first, can you guys hear me okay? Yeah. The first hypothetical, I think there's no First Amendment right to shout down the expression of someone with whom you disagree. This is not a new problem. In the 1850s, in the decade leading up to the Civil War, there were extreme examples of this where anti-slavery speakers were not just shouted down by pro-slavery speakers, they were physically attacked. And an organization called the Wide Awakes was created. There's a new book called Wide Awake. I never knew about these people, but these were uniformed young men who would go and physically protect anti-slavery speakers, abolitionists and other members of the Republican Party, and they would physically protect these speakers from attack. And I never knew anything about them, but they played a huge role in the 1860 presidential election that resulted in Abraham Lincoln being elected. So, you think this is a new thing, shouting down or trying to stop people from expressing a viewpoint that you don't like. It's not new. What's alarming to me is that this was happening right on the eve of a civil war, and you worry that we're on the eve of another civil war if this kind of thing can continue. On the second hypothetical, I think my answer would depend on the agreement that the university made with the student speaker. Did they impose whether they're even, I think that in the context of a graduation ceremony, it might be possible for the government to impose some limitations, although I would hope not. I would hope that at a public university there would be no limitation on what a student could say. But if there were some advance agreement, then you worry that the student may have been coerced into agreeing not to fully express her view. My view is that it's never harmful to have people express their views. And I need to stop talking, but 30 more seconds. That slide that I showed you of Louis Brandeis, do you guys remember? Good old Louis Brandeis. I didn't read from you his quotation from Whitney versus California, but what he said was that the remedy for evil counsels is good ones. And what he meant by that is that rather than shouting down someone whose views you oppose, you should engage in your own expression. That's the solution is more speech, not enforced silence.
Very consistent with Richard Perloff said. Richard?
Well, I think the interesting thing from a hostile media bias is that the people who are proposing to interrupt the speaker, are so convinced that that speaker is going to have a negative effect on LGBTQ attitudes. And of course, the speaker's speech is not anything that a lot of us would support, but that they're so convinced it's going to have an effect that they're willing to disrupt it. And that's what I mean by the power of their perceptions. What would be, and sometimes what happens then is this happened with Middlebury, with Charles Murray, who had some very obnoxious things in an earlier book about race. The other book was a little bit more nuanced, and the students protested that, and they were actually pretty violent to the professor. The professor there was a sociology professor who actually needed about 6 months of physical therapy. The case, I think, on Murray was a little bit more nuanced. This one, I think, is more obnoxious because they're totally against LGBTQ. But by doing that, what happens is it creates a climate of opinion where it's polarizing. And then that causes students not to want to participate. That causes other students to take sides. Well, they're on this side, they're on that side, and that causes people to exaggerate. What I think obviously it's not, there should not be an interruption like that on a speech, and there shouldn't have been an interruption. Not all of you may agree with me on Murray's speech, because what happens is there are better ways. There are better ways of the people who feel that way to confront it. Why not afterwards have a discussion? This happened with Chemerinsky, where the great civil rights scholar Chemerinsky he was dean of Berkeley Law School, and he had a student who interrupted, who was Palestinian, who said some very understandable things about the things that were going on in Palestine with the Israelis. And in that case there, Chemerinsky kind of took off his First Amendment perspective and say, it was a gathering he had at his house. And it was the gathering he had at his house at the end. And this student, kind of like the one that Dean Fisher said, kind of interrupted. But what I would have had, instead of having Chemerinsky say, you have to leave, I would have had him engage the person, said, well, this is what you believe about the Palestinians. Let's talk about it. And so in that sense, I think that the folks who were protesting the speaker lost an opportunity. As Mill said, I'll stop, they lost the opportunity there to if an opinion is right, they lose what is almost a greater benefit, the clearer perception and livelier impression of truth produced by its collision with error. The speaker was in error from a discrimination perspective, but had they talked about it, they would have produced the kind of truthful dialogue, I think, that a lot of people would have liked.
Any thoughts on the graduation speaker?
I think that one is a little bit more. That one I think you can understand a little bit more, because that kind of violates the context in which something's happening. And it seems as if the rules of the game, the contract, if you will, suggest that people are not expecting that kind of thing to happen. It's much more of a formal kind of situation. And that situation, I think, probably there should be a forum, a kind of a forum where that's acceptable. I don't think that's the forum in which it's allowed, in which it's acceptable.
Sonali.
Well, with the graduation speech, that sounded kind of familiar to me.
Yes. It was intended to.
Yeah, okay. So I agree that, that's a difficult one, but free speech nonetheless prevails. And I think that the reason it sounded familiar is that something very similar happened, and an opposing point of view or a counter view was expressed after the student made their speech. And so that's really, hopefully, what everyone will take from this, is that the best way to counter controversial or speech that you disagree with is to speak, have a countervailing or opposing view. So that's what I would say about the commencement. In the first instance, that follows along with what I was talking about in terms of how you express yourself on campus. So we would not say, oh, that person cannot come and speak, they're anti-LGBTQ+. They would be permitted to speak. Now, the problem I have, and because of the Forum Act, it says you can't have the heckler's veto. And you said that the students prevented the speaker from speaking. Yes. And that violates the law, and it violates our policy. So I would think that those students could be asked to leave or to sit down. And then, again, it's another opportunity to perhaps have a counter view after that speaker is permitted to go on and continue with their speech. But the heckler's veto, they cannot prevent you said that he was prevented from speaking, yes. And that's against the law.
Well, just for all of you know, neither of those were entirely hypotheticals. The first is what happened at Stanford Law School in March of 2023. Federal judge was shouted down, he was prevented from speaking, and the dean of the law school publicly apologized to the federal judge, but decided not to punish the students, but instead to have mandatory free speech panels like this. And that's how they resolved that one. With regard to the commencement, although it's not exactly what happened, at our law school commencement last May, some of you may know that one of our speakers, the president of the Student Bar Association, who's Palestinian, said some things, including, Richard, the term river to the sea. And I got up right afterwards as the master of ceremonies and simply said that I disagreed with what she said, but did not think this was the forum in which to get into detail why. And then I chose to focus on the things that she and I agreed on. But these are, the reason I mentioned these two things is that these are things that are happening every single day, not just on CSU's campus, but other campuses. And so I wanted to see how you'd react to both. Let's open it up to all of you. Anybody who wants to speak, all you have to do is stand, and then we have a mic. We'll bring it right over to you. Or you don't have to stand. You can just raise your hand. Anybody want to say anything? Yes, sir. Right over here. Give us a second to get to the mic. Even though you have a loud voice, let's wait anyway.
Yeah, my name's Bear Laughter here. I'm a film student transferring to theater. In regards to free speech, I was curious how, what would be the forum for the discourse over Chick-fil-A? Because Chick-fil-A is notorious for anti-gay, bi, lesbian, transgender, and I'm just curious how in the heck they exist here to begin with because of their stance against so much of our student population, and what would be the proper forum for addressing that free speech-wise.
Okay. Who wants to handle the Chick-fil-A issue? Kevin, I'll start with you.
Well, a forum can be created in any place at any time. If we go back to the public forum doctrine, which I didn't really have much of a chance to talk about, if you're going to use public property as a platform for engaging in free expression, then you'll be governed by the public forum doctrine. And so you want to choose a forum that will constitute a traditional public forum. So that's where the greatest free speech rights exist. The Supreme Court has construed a traditional public forum as a public park, a public square, a public street, and a public sidewalk. And in a traditional public forum, the government is not allowed to engage in any content or viewpoint-based restrictions at all. So if you wanted to express your views about Chick-fil-A, you could do it on a public sidewalk, you could do it in a public square or a public park, and there shouldn't be any ability on the part of the government to restrict the content or viewpoint of your speech.
Any other thoughts?
I think that it's important to note that that there are differences across countries. This reminds me of the Supreme Court decision with the abortion protesters, where the Supreme Court, I think, decided 5-4 that the abortion protesters had the right to kind of get in the anti-abortion protesters to get in the right of people who wanted an abortion, and they felt that was kind of, I think, maybe a little bit, generally under the public forum thing you're talking about.
Yeah.
But on the other hand, in Britain, It's the exact opposite. Now in London, it is now not acceptable for people to get as close in a public space to people who want an abortion. So I think it's important to remember that a lot of this is cultural. A lot of this is society-wise, and there isn't necessarily right or wrong. The First Amendment is a wonderful doctrine, but it isn't the only way of adjudicating. Countries like Germany have tougher hate speech laws. Maybe we should go that way, maybe we shouldn't. But it's just important to remember that we're brought up with a certain kind of cultural perspective. The First Amendment has benefits, it has costs, and it's interesting to take a wider perspective, because I think it opens your mind to appreciating that the way we do it in America isn't necessarily the only way you have to do it.
I'll just add that on Cleveland State's campus as a student, I did say that indoor spaces can be reserved for forums or student activity, and it would not be prohibited or limited in any way. The forum could be, dedicated to talking about Chick-fil-A. That would be in addition to the public forum areas around the campus where you wouldn't make a reservation. It would be a public forum. You could just express yourself in the public forum. The plaza, the plaza is a reservable space though. And you can be out on the plaza as a public forum unless it has been reserved by another group. And that would be the only exception to the public.
Okay. Do I have any other questions? Oh, right back there. Okay. You're getting your exercise. Let's make sure the next question's way over here, too. Yeah, okay? Okay.
So, Elizabeth Cravagna, I'm with the Honors College. Last year, CSU allowed some anti-abortion protesters to set up some extremely misleading pictures. I have my opinion on my right to choose. I have no problem with them being here per se. The issue, and where I'm wondering where the free speech policies come in, these folks did not stay within the confines of their very large display. They started to chase students throughout the plaza to the point where I was counseling students in the restrooms who had been accosted. Look at these pictures. Can you believe? I mean, they were attacked. Where does the university stand on people exercising their free speech but going beyond the bounds of the area that they've been given and literally attacking students, which seems to me to violate something?
Well, that's why I read the definition of harassment under the Forum Act, because that's really, I identify with that because we were hearing some of the complaints that we're being harassed, we're being chased down. What's not permitted is, direct threats or harm. Harassment is that's why I read the definition of it. It's a very difficult concept and a fine line. Let me look back. I don't have it committed to. These are the kinds of things that in my office, these are the kinds of things that we roundtable in my office. I see two of my lawyers out there, and we'd have to talk about. But, it really depends on if it says harassment means unwelcome conduct that is so severe, pervasive, and objectively offensive that it effectively denies an individual equal access to the individual's education, program, or activity. And so that's what we would look at. How far are they going? Are they harassing and threatening one person, or what is the situation? And you have to take it on a case by case. Kevin or Rick, do you have any other?
Nothing to add.
Okay. Other questions? Or you also can make comments too, if you don't have a question. Okay, we've got Kelly King, a lawyer. That was a compliment, Sonali.
Yes.
I was wondering, and feel free to decline, but if either of the faculty is willing to give their thoughts on, I've been reading in the national news about how some universities there's a call for some universities to speak out and take positions on certain issues. some universities are affirmatively, the university as the speaker itself, deciding to have policies that state we do not take public positions on issues. And maybe from the sociological perspective, I'd be interested in the wisdom of such a policy and the impact given just the traditional role of universities.
That came up last year with the whole Palestinian issue, and they tried to go to the University of Chicago theory of the Jeffrey Stone that you should not take a position. I think that itself, I don't think universities should make any ruling that rigid, because one can imagine on most situations, we probably shouldn't say anything, but one can imagine a situation that is so horrendous and so obscene that not saying anything is problematic. Racism, Holocaust, etc. So I think a university should refrain from making a policy on that. I think what they probably could try to do is punt a little bit and explain that that's not the role of a university is not to take a position on many issues, but they should try to leave an opportunity to suggest that a university is not just a force of kind of libertarian tolerance. That's the problem with John Stuart Mill. Every side is right, but on the other hand, majorities in culture have a way of licensing certain views. So I think a university should say, in general, we feel that we will not take a policy, but leave a moral high ground, leave an opportunity to say there could be some areas, some issues that are so morally offensive that not to say something is problematic. In that way, the university becomes not only a force of libertarian tolerance, but a force for morality. Now, how you decide it in the case is just a political football, but I think a university should stand for morality in some way.
Kevin and Sonali, any thoughts on that?
From a First Amendment standpoint, there's no requirement that someone speak, right? So that's how I look at it. There's no, my wife runs the Natural History Museum, and people were saying, well, are you going to take a stand? And my wife said, we've got dinosaurs here. Are we supposed to be taking a stand on public issues? So, I think it's often best to show restraint in this impulse to make a public statement every time, the news cycle changes. So my feeling is a university is supposed to be a forum. It's not supposed to be engaged affirmatively in speech. That's my view.
Well, I will tell you that I have a view that is more similar to Professor Perloff. But this is a hotly contested debate among law school deans, among university presidents, and there is no one right answer. The argument about not taking a position, it's a slippery slope. Where do you draw the line? Where do you make a statement? Where do you not? I've made a choice years ago that I was going to take positions, but I was going to speak for myself and not the law school. And so I was always very clear when I made those statements that I was speaking for myself. Now, some would say that's a distinction without a difference, and you're speaking for the law school in the eyes of other people. And that might be true. But I do believe there are times that you should take a stand, and I think taking a stand that says you will never do it is dangerous, just as dangerous as the slippery slope argument. So that's why I think you have to use your own judgment on a case-by-case basis. But I'm actually, I think, in the minority on that issue among at least my law deans. The majority of law deans don't take positions, but I do. We got one right here.
Hi, I guess most of you know I'm Bob Krebs. All I can say is that when I was leading the union here, we were often asked to take these sorts of views. And our view as a group, not just mine, was that the big problem comes in is that the harm you cause the minority by telling them that they're representing something they disagree with was greater than the benefit to those who wanted to get their view across. And so even at that time, we would, like, for example, stay completely away from politics because we recognize that we have a free speech and a free opinion, and we have different views. Yes, we're under the assumption that the majority of faculty probably vote Democrat. I think that's just, you can predict populations. But we never endorsed candidates because those people who wanted to choose otherwise didn't want to have to, have that point of view put into their mouths.
Somebody over here, question? Can I just say something while I walk on over there?
Sure, sure.
I just wanted to respond.
You got the mic.
She left. But what I was going to say when she was asking about the anti-abortion protest, when the police show up there, so there's no constitutional scholars out at these protests, right? Who's out there? It's the campus police, and they've got to make these decisions in like real time, and take all that stuff in consideration, the First Amendment and Ohio law and policies and all that kind of stuff. It is the most impossible job, really. I mean, they're not constitutional scholars, nor should they be or expected to be. So anyways, it's really difficult, and I give them credit because most of the time they do a fantastic job. So I don't know what happened in that particular case.
Hi, my name is Sayla Graham. I'm a student here in pre-law, and I know you guys touch on hate speech, but I know you, Mr. Fisher and Mr. Neal, showed like different opinions on whether it's protected. Can you clarify again, like how the campus would handle like an accusation of hate speech, and how is it defined if someone accuses you of it? Yeah.
Did you hear that?
I didn't.
I had a little trouble understanding it too.
I heard
sorry.
the definition.
I'll try again. I'm sorry.
That's all right. That's all right.
So I know, like, I watch a lot of debates, and often people, when they just don't like offensive speech, they'll just accuse someone of hate speech. How would the campus handle that?
I think she's asking about hate speech.
I don't know what she's asking.
I think
All right. Is the question, how do we know whether something's hate speech?
Yeah.
Is that the question?
Sure.
Yeah. Yeah.
How would you analyze whether something's hate speech or not, right?
Defining
Okay.
hate speech.
Okay.
Hate speech is not well defined. And the problem is that if you go back to 1989, in late 80s, early 90s, all the campus hate speech codes got struck down. Mm-hmm. And the reason they got struck down was under a concept called overbreadth. And if you go back to my slide on the unprotected categories of speech, if you're going to regulate the content of speech, and that's what you're doing when you regulate hate speech, you're singling out certain sentiments, certain viewpoints that you regard as hateful. That means you're engaged in content-based regulation. So you're facing strict scrutiny, which means that your hate speech code is going to be struck down. The way to avoid having your hate speech code struck down is to find one or more categories of unprotected speech and regulate within the unprotected boundaries of that category. And what happened in the late 80s and early 90s is that the University of Michigan, the University of Wisconsin, it imposed such sweeping restrictions on speech that those restrictions went far beyond the unprotected boundaries of any of the unprotected speech categories. So the courts used a doctrine called overbreadth. Under the overbreadth doctrine, when the government imposes content-based restrictions on speech, if those restrictions stray beyond the realm of the unprotected and punish lots of protected speech, the speech regulation will be struck down under the overbreadth doctrine. And all of those hate speech codes in the late 80s and early 90s got struck down under overbreadth. All of them defined hate speech so expansively that the prohibitions could not be kept within the unprotected boundaries of any of those 5 unprotected speech categories.
Any other thoughts? You could make a distinction, couldn't you, if there's hate speech is something that is threatening violence, then it may be crossing a line, but not if it's hate speech that is expressing bigotry or prejudice?
Yeah, should I go back? I mean,
You absolutely can go back to your slides anytime you'd like.
I mean, I made the slide so that we could be responsive.
Yeah.
Let me show you what I'm talking about. Okay.
While he's doing that, since you're pre-law, I'd like to talk to you before you leave. Okay. right?
Okay, there we go. Okay, so do you see over on the left-hand side, those 5 are completely unprotected. Now, Dean Fisher was talking about threats, true threats. That is an unprotected speech category, but all of the unprotected speech categories are extremely narrowly defined. And the Supreme Court recently decided, I think 2 terms ago, a true threats case. So what you have to have is a threat of violence that is communicated directly to the victim, and it must be intended to terrify the victim, and viewed objectively, the statement that the defendant made must, to a reasonable observer, be something that would reasonably inspire fear in the person receiving it. And the subjective intent of the speaker has to at least be a reckless lack of concern about whether they're terrifying the victim. So that's the new standard that the Supreme Court announced 2 years ago. So there's your definition of a true threat. And so now, if the threat that we're talking about in this particular case falls within that unprotected speech category, it can be punished. It can be criminalized with no offense to the First Amendment.
I would just add to that what happens in a lot of these protests is that people allege it's hate speech. They experience it as hate speech. So a Jewish person may experience that as the river to the sea as hate speech. A Palestinian may experience something as hate speech. And the difficulty with these passions is to help people get beyond that. And just as your abortion example is, people have very, very extreme attitudes. And so the only way, and some people you'll never reach, and some people will do violent things. The only way you can try to do it is by trying to have some kind of forum at the university, some kind of safe space where people on both sides can feel that they'll be respected. Because the attributions, which are not necessarily in touch with the law, are what get us in trouble. And that's where I'd like to see tolerance as a platitude. It's hard to get tolerance in American society. But it's something that I think universities have a special ability to try to do, because young minds are more susceptible to influence by opinion leaders they respect.
Thank you. Anybody else? If not, we'll go to another question over here.
All right, I'm going to test my memory and maybe yours, Dr. Fisher. If I remember back in the days of Taft, this is directly pertained to, I guess, the Ohio, universities in Ohio, when it came up in Cleveland State in a discussion, was a rule that came out, and I think it was, they were trying to get it through the legislature, and I was kind of asking if it did get through the legislature and if it still holds, that barred faculty from discussing politics in classes unless it directly pertained to the curriculum of that class. I'm sure that's violated all the time. Nonetheless, is that protected free speech in the classroom, or is that something that can be controlled or regulated at the university?
That's an interesting question. I think as I understand it, can a legislature, is that what you're saying, pass?
Can we actually?
Yeah, can a legislature, in other words, under current law, you mean? Well, I think, let me just make sure I understand. You're asking, can the legislature pass a law that would indicate how somebody can teach a class and what content that would be, or are you asking, is there a law, such a law? Or both?
Both, actually.
Both.
You worded it in a very, I think the answer would be no. They can't tell us how and what to teach. But
Yeah.
can we restrict particular topics?
Okay. I'm not aware of such a law, but I may be wrong.
I don't think that the legislature can, but I think that, and this has come up where certain topics, it has to be part of the accepted method for that discipline. And if it goes outside of that, then it can be limited or restricted. So it's academically, is that within the realm of that subject area. I think that's how it's analyzed in the classroom. But I don't think the legislature can, I would imagine that would be challenged under academic freedom.
Any other thoughts on that? I agree. I think it would be a clear violation of academic freedom for a legislature to do that, and I don't think it would pass constitutional muster, but that's my thought.
On that point, I think where the difference, I don't know if correct me if I'm wrong, but the difference is, for example, let's pick a real touchy subject, the Nazis. The difference between a class teaching on the history of Nazis versus a class teaching how to resurrect the Nazi movement. Is that the type of difference in classes you're talking about? Which one will be restricted?
Well, I think your hypothetical, since I think we've addressed the first one, let's go to your hypothetical, which I think is a more difficult one. And that is, can you prohibit someone from teaching a course in which they're advocating and promoting and supporting the Nazi philosophy? Right? That's a tough one. Sure, I get it, right. And by the way, that kind of thing, it's not a pure hypothetical. Those kinds of things have happened on campuses. Does our panel want to tackle that one? No?
No, I will say that
Yeah, okay. Sure, I understand.
my deputy has a view. Kelly, why don't you say she was trying to...
I was going to say another resource that we have available for faculty and staff is the Faculty and Staff Political Activity Frequently Asked Questions on our free speech website. Provides guidance as to, in our capacity as employees and in our capacity as individuals, what is permitted under state law. So I would recommend that resource.
On your hypothetical, I don't know the answer from a legal standpoint, but I can tell you that if a professor at the law school were advocating such a position, I would go with what Professor O'Neill and Professor Perloff says, and I would engage in more speech. And I would immediately denounce it and criticize it. But whether or not I have the right to prevent it is a more difficult question.
I'd like to hear Professor O'Neill's opinion on how Columbia University handled the protest and encampments last spring.
Well, brilliantly, I thought. I just thought they did a great job. No, it's now that's a private university, so the First Amendment doesn't apply, which means it all depends upon the policies that the university adopts. And I think that they were caught unprepared. It's interesting that the protesters were taking pages out of the Occupy Wall Street playbook. Now that's a movement that I've studied pretty carefully. So you have the encampments, for example, the perpetual encampments where they just make an encampment and they won't go away. That's straight out of Occupy Wall Street. Now, if the First Amendment applies, you have a large number of Occupy Wall Street decisions by the federal courts that were handed down in the years following 2012. And Occupy Wall Street lost, except for one case where the government behaved so ridiculously. This was good old South Carolina, of course. They adopted a secret policy, and then tried to enforce it. And the court said, "Come on now, a secret policy? Let's try to do better than that, South Carolina legislature." But aside from that, so when you have the government just being stupid, then they're going to lose out of stupidity there. That's a technical legal term. But in all of the other cases, the courts applied just time, place, and manner restrictions. And the courts held that there's no First Amendment right to the perpetual occupation of a forum. Now, if the First Amendment doesn't apply, and it didn't at Columbia, what do? If you don't have a policy in place and then you start to enact policies retroactively, and it looks like you're engaged in the adoption of policies meant to punish after the fact what these kids are doing, well, now you're not looking so good, and that's what happened at Columbia.
I'd like to touch on that as well. A lot of schools do have, whether it's a public institution that now is required to have policies and rules and procedures. Case Western, when their campus was occupied, they have a no encampment policy. They have policies that govern, even though it's a private institution, right? They had the encampment rule, and it's my understanding that they negotiated basically with we have this rule that you can't camp out. We'll let you camp out for, let's say, 2 days, 3 days. I don't remember how long it was. And then when that time was up, it was up, and the protesters left. So they handled it through. They already had. They were prepared, to your point, and then it went off without a lot of violence and so forth. So. Oh. Mm-hmm. Yeah.
Yeah.
Any other questions? You are all, oh yeah, we do have one
This
more
is a
question.
comment,
Just, this is going to be the last question
Okay,
because there's a vice presidential debate tonight that everybody wants to get to, so go ahead.
This is a comment having been on the opposite side of the Occupy. I personally have friends that formed several of the Occupies, Occupy Portland, Occupy New Orleans. Mm-hmm. I was on the side of many of the Occupy, and where, as you pointed out, is the time, place. Almost all of them negotiated the Occupy was there, but they had such a high turnover of people traveling from Occupy to Occupy to Occupy that some of them were only there for 3 or 4 days, even though the encampment was there for a month and a half. And it was interesting to be on the other side, where I was part of the Occupy protests, and it was interesting how, for being so much anti-government, the Occupy protests were, how much they coordinated with the local governments just so there was not the violence.
Kevin, any comment on that?
No, I think you're right. Yeah. There was litigation all over the country involving Occupy Wall Street, and I've charted all those cases, and there were variations on the ground in terms of how the protesters negotiated. Some of them, like in Oakland, refused to negotiate at all. So that there were variations. But I remember there was a federal judge in Boston who reacted with particular anger to the idea that you could just occupy a public park indefinitely. And what he said was, what if somebody else wants to engage in protest? You shouldn't be allowed to just sort of set up shop in a public park, which is a valuable free speech location, and sort of monopolize it to yourself. And so that was the reason that he ruled as readily as he did against Occupy in the Boston case, was because he just felt that, the whole idea of the public forum doctrine is that we're supposed to share these unusual government platforms, the public parks, the public squares. They're precious, and there's not that many of them in a community. So they're to be shared and not monopolized, and that was his view.
I like to end every panel discussion with asking each panelist to give one takeaway that they would like the audience to remember about what they said. And Professor O'Neill, since you went first, unfortunately, you have to do it first.
Yes, I just want you all to remember that I am known at the law school principally for the fact that I lost that case to Lee Fisher. And as a consequence, I have been carrying his briefcase for the last 20 years.
No, give us another takeaway. That's not the right takeaway.
And it's a really heavy briefcase. That's my second point. No, it was a pleasure to address you. I hope that you'll remember the basic distinction between content-based and content-neutral time, place, and manner regulations, and the fact that the time, place, and manner regulations are gauged under a much more deferential standard. Don't forget about Holmes and Brandeis. They're the heroes of American First Amendment law. They're the ones who first drew the line and said, we got to get the government out of the business of serving as a content-conscious gatekeeper, deciding that some ideas are allowed into the realm of public discourse, but others are not.
Thank you. Professor Perloff?
I would say that perceptions matter, that how people perceive is not necessarily the accurate way of looking at it, but we got to respect those perceptions, and that people will come up with all sorts of different ways of looking at the same phenomena. And as I say, we should be safe from harm, but not safe from ideas. And so I think it's very important to help people get away, especially our students, to help them take away, separate out the person from the political and appreciate. And I also want to say that what Professor Kevin O'Neill was saying about democracy is really interesting, that what Brandeis was talking about was not only the intrinsic right of free speech, but that free speech and tolerant speech is important for democracy. That you cannot have a vital democracy unless there is free speech. And of course, that's now very, very complicated with misinformation on the internet, where there's no easy answers to this. We need to have free speech, but we also have to have ways to help people correct the free speech that is injurious and also is inaccurate.
Thank you. Sonali?
Cleveland State University is an instrumentality of the state of Ohio, and so it is the government. We do have policies and we have procedures. The policies are what is free speech, what's protected, and the procedures are how to effectively exercise your rights on this campus. And I think that I would like everyone to go to the free speech website that lists out all of our policies, procedures. We have political FAQs for faculty and staff. We have political FAQs for students. And we have a means of complaining or filing a report if you think that free speech has been violated on campus, and that will be a great resource for you all.
Please join me in thanking Vice President and General Counsel Sonali Wilson, Professor Richard Perloff, and Professor Kevin O'Neill. Outstanding panel. Thank you all for staying. I wish I could give you extra credit.